Hello, everyone, and thank you for joining us today on our webinar, Recent Trends Impacting International Students and Steps You Can Take. I am joined today very graciously by Carolyn Lee, who I have been fortunate to be friends with and to work with for over 20 years at this point. So in terms of advising our clients and international students looking at EB-5 about what is happening during this very interesting time, Carolyn Lee could not be, can definitely speak to all your questions and concerns. We've worked with her in many ways over the years, so it's our pleasure to have you here today.
Oh, Christine, thank you so much. What a pleasure. And I mean, we've grown up together, you know. If we look back a couple of decades, we were like 5 when we met and
Absolutely.
and savants in EB-5. We were just doing stuff. Yeah, so it's just wonderful to be with you and with CanAm.
And I just want to say, you know, over the years working together, I've always called you the fairy godmother of EB-5 because you've always taken such a optimistic and advocate kind of position for EB-5, but in a fair, transparent way, which I think is just really cannot be valued in the past that we've had with EB-5, but in moving forward as well. There's so much information now, which is great. But you really make sure that, you know, our clients, your clients have the right information to make the decisions they need to make. So it's really just been a real treasure being able to work with you over the years.
Well, Christine, right back at you. CanAm is best in class, industry leader, and integrity leads the way for you. So I think we have shared values.
Absolutely. Absolutely. And I think that's what is so important in having you talk to us today. I think with, you know, there's been so much going on in general, but a lot of international students have been really getting a lot of attention from USCIS and ICE and the Trump administration. It's definitely been hitting the headlines, which, you know, every time you think that, you know, what you're doing is totally compliant, then you start wondering, you know, what if something else beyond that might impact me? So I know you have, you know, definitely seen cases of this. So I would love to hear from you, your take on what's happening with F1s right now, what you're seeing with your clients on campuses and experiences and kind of the concerns that are in the headlines right now.
Totally, yes. Well, these are unexpected developments, and they've caused tremendous amount of concern internationally within our F1 student population and their families abroad.
Yes.
Right? And so I think the genesis of these F1 visa revocations have been a series of executive orders, really dating back to the first Trump administration. And specifically, they're targeted toward anti-Semitic student activities. And they've morphed a little bit. The scope of the executive orders and the interest have expanded to interests that are adverse to US foreign policy.
Mm-hmm.
And it's under these umbrellas that the F1 visas are being revoked, which the State Department has plenary authority to do. So statutorily, the State Department has authority to revoke visas. And the visas, of course, technically are travel documents. They're the stamps that are affixed to the passports. And they don't govern status, but they're presented upon seeking admission to the United States. CBP inspects the visas and admits the students in F1 status. And so once they're in the United States, their status is no longer going to be governed by the visas, but by their CVIS F1 I-20 records. And so what we're seeing is one or the other or both, the F1 visa revocations from state and F1 visa status terminations on the CVIS side by ICE.
So for someone who has entered the US, they feel secure, having gotten their F1, they've gone back and forth. All of a sudden, this is a dramatic change in what they've probably been experiencing for, the past several years. What are you, and they're probably thinking, but I don't have any, I'm not a target. I haven't done anything. What are you seeing as reasons students are kind of seeing these notices and these revocations and terminations that they might not have seen before? They might not think, why am I seeing these all of a sudden?
Sometimes the students don't know why. Because the reason provided in the CVIS database is failure to maintain status.
Right.
So, and in fact, there have been some cases where students have experienced status terminations in CVIS. They didn't know why, the school didn't know why, it was discovered in scanning the CVIS records of students. And so those cases have been the basis of reinstatements and successful court actions for temporary restraining orders. In other instances, we're hearing the students kind of guess. You know, they say a couple of years ago or 3 years ago, I had an altercation with my boyfriend or girlfriend, and I had an arrest, and I was questioned by the police, and there were no charges, everything was expunged, and I've been issued F1 visas subsequently.
Right.
So thought nothing of it. And the F1 visa has been revoked and the CVIS record terminated.
So, I guess to kind of differentiate between a visa revocation versus a CVIS record termination, how would you distinguish those so people can understand one versus the other, and in terms of where they are in the process, if they got either notice?
Great question. Great question. So visa revocations are not new. The way in which it's been happening is new, specifically targeting F1 students. And so when a visa has been revoked, that visa is no longer valid for travel. And so when the person leaves the United States, that person would have to reapply for the visa. And it's in the course of reapplication that any inadmissibility issues or reasons for revocation would be addressed and the subsequent visa issued if everything goes well. So that's on the visa revocation side. It's a travel document issue primarily, but we'll circle back to that.
Mm-hmm.
In the status termination side, everyone has to be maintaining status in the United States. So if you're no longer maintaining status and your CVIS I-20 record's been terminated, you're no longer in status. And under ICE policy, you must leave immediately. There is no grace period. Now, I think it's worth noting that on the visa revocation side, that's how typically the revocations have gone. And it could have been anybody, right? H's, O's, E's, whomever. There is some prudential reason perhaps for the State Department to revoke the visa. And so that's done, a reapplication is made later. Now, there is a exclusion ground, a ground for removal that could be triggered if the visa is revoked. So that is sort of the fear, the cloud. It's beyond the possibility of, a visa revocation and you make a reapplication. There is the specter of a notice to appear and removal proceedings also being instituted as a result.
So I guess, in an F1 kind of environment, what does a visa revocation look like? I mean, what would be the reasons and grounds? I imagine everyone's thinking criminal activity or things like that, but I suspect, as we have seen with a lot of these, it can be much more mundane than that.
Great. It's a fantastic way to put it. It can be mundane. There could be no good reason because the visas can be revoked as a matter of discretion. And so if we think about the State Department and the visa issuing consulates, the consular departments, I mean, they're really the gatekeepers for the borders of the US, right? And so by design, they have plenary discretion to simply say no visa, you can't come in. And so the visa revocation is an extension of that discretionary authority exercised over visa holders who've used that visa to come into the US.
So if you were a student and you're worried, but you're obeying the laws, you're not going to commit a crime, and if you do get a notice of any sort, what would you be recommending to your clients in terms of just paperwork, documentation, anything else that they might want to just keep an eye on in case they have it, so that they have as ready as possible what will be needed by an immigration attorney to supply to try to remedy the situation?
Yeah, so very, very practical stuff. You know, first of all, have all of your immigration documents readily on your person, not necessarily like physical paper copies of the I-20, but have good photocopies on your phone. So that if you need to refer to it, if you need to show it to anybody, it's right there. All of your relevant contact information should also be on your person. So have a contact person at your International Student Scholars Office, the designated school official, DSO, that you can contact. And also practically, this is sort of practical advice, have somebody who knows you, make contact at your DSO's office so that if you call somebody, you can ask for somebody by name, that you've made personal contact with someone. Also tune into the announcements, messages, newsletters, public announcements made by the DSO's office. They may have announcements and positions that they want the students to be aware of. So for example, advisory against travel. Many schools have this out in this environment. And so you want to be tuned into that. You may have further questions about it, but you want to be tuned into what your school officials are messaging out to you. I also think it's a good idea to have a buddy. And I recommend this for, you know, all of my dear F1 clients and anybody I know really traveling abroad, is you want somebody who is aware of your schedule, so that if you're not at the dining hall, or if you miss a club activity, or you're not in class for 2 days, somebody is noticing that. And I think that's also important.
Absolutely. I mean, these are, you know, to your point, you call it practical, and someone else might call it very common sense. But the truth is, kind of having these things in order, it's just a sense of reassurance, you know, and being prepared. I think that, you know, the DSO in particular should be really viewed as not just a kind of a practical resource, but in this environment, really a resource in terms of, you know, policy, best practices. In this time, I have to believe that all of them are really gearing up and preparing materials and resources for international students at their school. And so they should not be underestimated as a resource.
100%, 100%. And the DSO's office could be in the student's corner in putting their remedies and their solutions in play. So for example, one of the remedies that the student might be seeking is reinstatement. And to do that, they're going to need the DSO's support.
Absolutely. And I think, you know, if you have to go to that point where even if you're seeking immigration counsel to help you prepare for all that, you know, having all those contacts available, because they're working together all for the benefit of the F1 student. You know, I think that certainly sometimes when you come, you know, to a foreign country to study, you're thinking, I'm going to obey all the rules and be very differential, and you know, the DSO might be viewed as almost like an enforcement type, you know, role, but it's not, you know.
Yeah, in this context,
Mhm.
that's right. I mean, traditionally, it would be the DSO that would initiate the CVIS record termination. So if a student doesn't show up to class and they're not maintaining their full course load, they're the ones, and then they would send a letter saying, we're terminating your CVIS record. But in this instance, the DSOs are really on the student's side, and they want to assist the student.
Absolutely.
Yeah.
And I think it's a big change kind of in perception. So it's a little bit, you know, unfortunate that they have to play this role in this kind of situation, but they should really be viewed differently than perhaps they have been.
Absolutely, absolutely.
So I know you have had clients come to you. You've dealt with, you know, real cases of F1 students having gotten notices of revocation or terminations. I guess it would be great to share a little bit with everyone who's listening What have you been seeing as ultimately the path to clear their revocations or termination notices and remedies on kind of the simple, straightforward administrative kind of side, and what have been kind of tougher cases to deal with? Just kind of see what real life wins there might be in this environment.
Well, I'm happy to kind of walk you through the gamut.
That'd be great.
Yeah, so I think the luckiest of the batch are students who have filed a concurrent adjustment of status applications. So the students who have concurrently filed their EB-5 and adjustment of status applications, the adjustment of status is another basis for lawful presence in the United States. So they're not reliant solely on their F1 status. So that's a plus factor number one. Now, that's not a perfect shield, but a way in which that concurrent adjustment of status application can come pretty close to that is where the student has already exercised that advanced parole. Because the adjustment of status applicant can apply for concurrently also work authorization EAD application and travel permission, the advanced parole application. And once that advanced parole issues, the student can use that to leave the US and return. And when they return using that parole document, they're not returning as F1s, using that visa that could be later revoked and trigger removal, or under the I-20. So in the case of a parole, and we have clients like this, F1 students who have departed, returned on advanced paroles, they're not subject to the consequences of the F1 visa revocations and CBIS terminations because they're not in that sphere.
I think this is a really important thing to highlight. You know, EB-5, since the RIA was passed, has become a huge area for F1 students who have ultimately decided to stay in the US beyond graduation. And so this has really just afforded them, they really have to see themselves not as F1 students anymore, but EB-5 investors. And that's what they're traveling on.
And it's remarkable to me, Christine, because concurrent adjustment of status is a gift that just keeps on giving. I mean, we've had clients who are who didn't get in the H-1B lottery, and they're out of OPT time. And now they have adjustment of status EADs and they can keep working. So it's just been phenomenal. And then their spouses, you know, the students get married or they were married and their spouses can get an EAD, an adjustment of status application. So it's just been this fantastic experience. And now this as a potential remedy for students as well. So it's remarkable.
And I think, you know, for anyone who is doing that, to not take your time to act on your adjustment, but really, you know, take action on your EB-5 visa as soon as possible to make that your effective status in the United States is just really important to create.
And to consult your attorney.
Yes.
You know, these are all case-by-case scenarios. There might be other background factors to take into consideration, really important. So I think it's a good segue to say, we're not giving legal advice here, folks, but we're certainly, you know, sharing experiences that should be food for thought.
Yeah. And I think, you know, for F1 students who have kind of decided that their future is in the United States, and that's why they've, say, invested in an EB-5 and adjusted, you know, there's just so many more protective benefits than they even anticipated moving forward. It's not a simplification of their status. It really has afforded them a lot more protection than others have.
Yeah. Yes, concurrent adjustment of status filings. And then the other thing to report, even for students who don't have concurrent AOS or EB-5 in the horizon, EB-5 can prospectively and concurrent adjustment of status, as long as there's visa availability, could also potentially afford a student whose record's been terminated a way back in through adjustment of status application and a carve out that we have under the RIA for certain adjustees who can still file for adjustment, even though they're out of status at the time of filing the adjustment. Again, this is something that should be consulted with the attorney, but that is another potential solution. And then for students who don't have EB5, there's also good news provisionally on the out there, which is the success of the TROs. So students are having success suing in district court and getting their statuses reinstated.
Yes. You know, I think the ALA community really has banded together tremendously to try to share this information, make this information widely available for any, you know, F1 student who is trying to understand or even proactively understand what their options are. There's been so much, you know, really invested discussion going on around this with some of the best practitioners in the space. So I know that you've heard on all the committees that you're in ALA about all the efforts that are kind of going on. So it's just really a big kudos to kind of everyone who really cares and is trying to protect you know, their clients in this crazy environment. It's become much more volatile than it ever was. So it's just, I know it's a ton of work and people are filing multitudes of applications at the same time just to be able to protect their clients. So I'm sure that's been a lot of that's been going on with you, with your team.
I mean, I'll tell you, I've looked in areas of the law that, you know, I don't think I've looked at for probably a decade. Yes, we're all having to, you know, come outside of our comfort zones and think creatively and look really into the authority here.
And, you know, I think that definitely more pushback is definitely has caused some of the wins you've had, you know, to kind of pave a path forward that can be replicated, a path towards success that can be replicated. It's the only way to kind of diffuse some of the panic that these kinds of executive orders are trying to generate.
Well, and you know, to your point too, I think it feels it's I hope reassuring to the families and the students that they're advocates. You know, they have people in their corner pushing for them.
Absolutely. So, you know, obviously we are not, as you said, each case is individually treated, has individual circumstances. We're not providing um, legal guidance on this webinar, but for you to be able to share some of what you've seen, best practices to kind of protect yourself if you're taken or get notice. I just think it's really important for our clients, your clients, to be informed and just be able to recognize their allies in this environment. It's hard when you're new to a country, even if you've been here for a few years, to know who to trust. So.
Absolutely, absolutely. You know, and the advice is really just practical stuff, you know. We have a saying in our office, in times of uncertainty, act wisely. And a lot of it is just take a moment, you know, take little for granted, you know, take the time to really understand what are my requirements, because they're being enforced. So really, you know, understand what you're getting into, what you have to do, stay within the bounds, don't push the envelope. If there are questions, ask, figure out who you should ask. And identify your, you know, people in your corner and turn to them.
Absolutely. I mean, this doesn't have to be done by guesswork or looking online. There's real people out there who are resources and getting that information. And you and I have always talked about how, you know, being informed and educated is the best way to create a sense of calm and predictability when there isn't any to be had. And I think that definitely applies in this case. So.
Indeed, indeed.
So thank you so much for this kind of brief discussion. I think, you know, it really has been so meaningful to be able to talk to you and have you share with, you know, F1 students or EB5 who have converted from F1s to just kind of hear straight from you what you've been seeing and put some of their questions hopefully to rest.
Well, Christine, thanks to you and CanAm for creating this platform and getting the message out there.
And
Kudos to you.
oh, no, thank you so much. We really appreciate it. It's been wonderful talking to you. I'll see you soon.
See you soon.
you so much. And thank you, everyone. We really felt it was important to be able to get a dialogue going on about this. This is not to be the end of the discussion. As Carolyn very aptly put it, it is supposed to be reach out to the resources that you have, find out who they are, get the information. It's easy to feel disadvantaged in these circumstances, but you don't have to be. So thank you so much, and we look forward to talking to everyone again soon.
Thank you, Christine.
Thank you.
Be
Bye.
well. Bye.